Of the petitioners in the case of state. If the Lordship may permit, may I please much obliged, Your Lordship. Your Lordship, case in 3 stages, Your Lordship. First, 7, Your Lordship. The constitutional amendment 2020, 2020. Your Lordship. It has modified Article 156 and Article 155 tells that the appointment for panel of through a process of indirect election by vote by the state legislation if a legislative assembly, Your Lordship. And then of Article 158 subclass the governor's, Your Lordship. It says that government, Your Lordship. Your Lordship, what I will state legislature or the member of parliament is no political inference or the Your Lordship. Moving on, this 2025, the newly elected government amendment, Your Lordship. This gives rise to the which the Constitution provides under Article 131 subclass A of the Constitution, Your Lordship. Moving on, the second part of the issue is that where the union government has given a draft UGC resolution which was adopted by most of the states, Your Lordship. Then, in response to
adopted the UGC regulations?
Yes, Your Lordship.
Where? You are preparing now.
I am searching for the exact line, Your Lordship.
That's what I am saying.
Your Lordship, in page 5 of the MOOT proposition, in paragraph 4, Your Lordship, it says, in this situation, another center state tussle also arose in the field of education. The union government has introduced a draft UGC regulation 2025.
There's no need to read that. You can proceed.
Yes, Your Lordship. It says the same was adopted within a span of 1 month, Your Lordship. Moving on, Your Lordship, with this, in response to the regulations, the state government of Tamil Nadu has amended its own state university regulation stating that the chancellor position will be governed by the chief minister who will appoint the selection committee and the academic senate, Your Lordship, which is in direct contradiction with the UGC regulation that was given by the union, which said governor will be the chancellor and he will appoint the vice chancellor, Your Lordship. This is in direct contradiction with the UGC regulation given by the union government, Your Lordship. For this, Your Lordship, to clarify this position, the president has invoked their advisory jurisdiction.
You are addressing issue number 1.
Yes, Your Lordship, I am explaining the facts of the case, Your Lordship, with the jurisdiction.
Are you with issue number 1?
Yes, Your Lordship. I will be dealing with issue number 1 and my co-counsel will be dealing with issue 2 and 3, Your Lordship. So, the President invoked the advisory jurisdiction under Article 143, where 143 which is pending in the Supreme Court, Your Lordship. Moving on, with this being pending in the Supreme Court, the Union Government has introduced the next amendment, that is 109th Amendment, which makes that if a governor withholds the bill without passing for more than 6 months, it automatically transfers to the President for assent, Your Lordship. This was the question in the Constitution Amendment 109, Your Lordship. The several state governments have removed their original jurisdiction under Article 131A to challenge this Constitution Amendment 109, Your Lordship. This gives rise to the third issue, Your Lordship. The Supreme Court has, under its discretionary power, has consolidated all the 3 issues and has put before this Honorable Court for a final hearing today, Your Lordship.
Discretionary power of the Supreme Court.
Your Lordship, the Supreme Court has the power
Where it is kept in the Constitution?
Your Lordship, Article 139A talks about the transfer of cases, Your Lordship. But it says that...
You say about discretion of cases.
Yes, Your
Now
Lordship.
you are saying about the transfer of cases.
Your Lordship, Article 139A says that if in 139A, if case is pending before several high courts, can be transferred to the Supreme Court for its final hearing, and the order can be passed to the High Court, Your Lordship, if it involves the same substantial question of law and if it is of public importance, Your Lordship. But that jurisdiction involved in High Court, the Supreme...
You say that transfer of cases alone is the discretionary power of the Supreme Court.
Your Lordship, transfer of cases is governed under Article 139A of the Constitution from High Court, Your Lordship. But as all the 3 petitions have been filed in the Supreme Court directly, the Supreme Court does not need an constitutional mandate, Your Lordship. It uses its discretionary power to club the cases and put forward the final hearing, Your Lordship.
That's what you are saying, that it is a discretionary power.
Yes, Your Lordship.
Yes. Proceed.
With this, can I move on to the arguments advanced, Your Lordship? Much obliged. Issue 1 deals with that whether the Constitution Amendment 107 is valid and Constitution Amendment 108 nullifies it. Is the question valid, Your Lordship? I would like to substantiate my arguments in 3-fold manner, Your Lordship. Firstly, for a Constitutional Amendment to be unconstitutional or void, there has to be 3 conditions that has to be fulfilled, Your Lordship. All the 3 conditions have been derived from the various landmark judgments of case on the party, such and such cases, Your Lordship. The 3 conditions that has to be fulfilled are: firstly, there has to be procedural instability, Your Lordship. Secondly, there should be violation of the basic structure doctrine. And then thirdly, the part 3 of the Constitution, that is, which deals with the fundamental rights, should not be intact with the Constitutional Amendment, Your Lordship. In the present case, as the proposition is silent about the procedural inconsistency or procedural thing, Your Lordship, the second condition, that is the violation of basic structure doctrine, can be applied here, Your Lordship. The Constitutional Amendment 108 directly
Actually, your submission is that the 108th Amendment violates basic feature of the Constitution.
Yes, Your Lordship.
Do you admit that 108 only restores the earlier provision, which is the original provision of the Constitution?
Yes, Your Lordship.
Then do you mean to say that the original provision of the Constitution was violated of the basic feature of the Constitution itself?
No, Your Lordship. The 108 Amendment, although it has nullified the earlier amendment, the position of Amendment 107 was better than the position of 108, Your Lordship. Although our Constitution is 75 years old and all...
No, I'm not on the subject. Your subjective opinion of whether 107 was better or 108 was better than 107. My question is very simple.
Yes,
108 only restores the original Constitution provision.
Yes, Your Lordship.
Your argument here is that the 108th Amendment is violative of the basic feature of the Constitution. Then you are indirectly meaning to say that the original provision of the Constitution itself was violative of the basic feature. Can that be?
Your Lordship, as Constitution Amendment 108 affects the state autonomy and federal structure of the union and state, Constitution Amendment 108 restoring the position of 107 is not valid, Your Lordship. I get your question, Your Lordship, but
You have not answered my question.
Your Lordship, as evolution of Constitution is required, which has been held in the landmark case of it says with the constitution, with the provisions of the constitution.
Maybe you have an answer.
Yes, the Constitutional Amendment Act 108, it widens the basic structure, but it, although it resorts to its original position of the Constitution, violation is there, Your Lordship. So that we would like to put forward the amendment so that to cure the violation in the Constitution, Your Lordship. That is why Constitutional Amendment 107 was implemented, Your Lordship.
So the appointment of the governors is concerned, the earlier provision states how they can be appointed, how they can be removed. See, you can differentiate what is the new amendment, the parliament, so far the enactment of the governor's appointment and removal. You will briefly say about that.
Yes, Your Lordship.
We have produced the several judgments and the quotations also say what is the powers of the governor, how they can be appointed and how they can be removed. Now the new amendment 107 and 108 you have said that how they can be appointed, what is the powers vested with them, how they can be removed. That you should establish. You have said very correctly, it may be, should not be in a political appointment. By the new appointment, it will be given political color. That is the observation of your argument.
Yes, Your
And
Lordship.
another argument of you is concerned that we understand to our knowledge that you like to focus before this court is concerned that the powers of appointment of the governors are concerned should be given to the state. That is the voice of the state. Is it not? That is your argument.
Yes, Your Lordship.
That you would like to produce this Kesavananda Bharati's case. The national Kesavananda Bharati is concerned not to discuss about the powers of the governor. It says the basic structure of the constitution is shaken or attacked, whether it can be given retrospectivity or prospectivity. That is the observation of the Supreme Court. Did you find that?
Yes, Your Lordship. As you stated, the landmark case of Kesavananda Bharati, the main judgment that was given was that the power vested under Article 368 is limited. It cannot affect the doctrine of basic structure doctrine, Your Lordship. It also said that prospective overruling, Your Lordship.
Prospective overruling.
Yes, Your Lordship. The amendment cannot act retrospectively. It can act only in the future, Your Lordship.
Correct.
This was a rationale that was given in case of the Bharati case as well, Your Lordship.
What way this affecting the basic structure? What is the basic structure?
Yes, yes, Your Lordship. Your Lordship, I would like to answer to the question proposed by Shah and then move on. Yes, certainly, Your Lordship. Your Lordship, the validity of 107, the Constitutional Amendment Act, is much more than the, is valid, Your Lordship. First, I would like to unfold it in a four-point perspective, Your Lordship. Firstly, it strengthens federalism and it does not violate the concept of federalism, Your Lordship. Although India is a quasi-federal state and it follows the concept of cooperative federalism, vesting the power as the governor is the...
Sorry, what is the source of the expression you used, quasi-federal?
where does I get the power from?
No, you say that India is a quasi-federal constitution.
Yes, Your Lordship.
What is the source of your statement?
Whether any such terminology like quasi-federalism has been explained under the Constitution.
Or the Supreme Court or the High Court, whatever. What is the source?
How do you find that term quasi-federal?
Yes, Your Lordship.
Although it's a federal setup, basically.
Yes, Your Lordship. Your Lordship, Article 1 of the Indian Constitution says
No,
India is
I
a
want to know the source.
the Constitution, Your Lordship.
Article 1.
God, it does not explicitly says federal constitution, the word federalism, Your Lordship, but the meaning of the word India, that is...
As we understand that India is a federal constitution.
Yes, Your Lordship.
Because we have in several judgments upheld that federalism is basic feature of the constitution that gives power to make all your submissions. But you use the term quasi-federalism, which is against you. So I would like to know from where you got this term quasi-federalism, which is against you. You are making a submission that is against you.
Yes, Your Lordship. Your Lordship, although India is a federal state, all the features of a federal state, all the unity
You are not answering my question. You can move on.
Yes.
You can
Certainly,
move on.
Proceed.
certainly, Your Lordship. Your Lordship, the first submission that I would like to put forth is that the Constitutional Amendment 107 does not remove union participation, Your Lordship. Firstly, the proposition says that Article 155, 4 candidates will be nominated by the President. Out of the 4 candidates nominated by the President, the state government will select one candidate to the PROF of Indian election, Your Lordship, which is forward for the election of President as well, Your Lordship. Here, Schedule 7 specifies the powers of each government, your lordship. Thus, union government has its own power, state government has its own power. With that, there is no
The whatever amendment was brought, 107 or 108, they did not enhance or diminish the powers of the governor. They only speak of the manner in which the governor is appointed.
Yes,
How
Your
does it affect the powers of the state government?
Yes, your lordship. Your lordship, firstly, this the concept of checks and balances and state autonomy is affected here, your lordship. The governor is the constitutional head of the state, your lordship. Yes, your lordship. Yes, your lordship.
You have autonomy.
No, your lordship. The state's autonomy in its own administrative matters is interfered by the union, your lordship. As state has its own power, union has its own power. The state influence the union.
The question is, only the procedure adopted for the election of the governor is being under challenge.
Yes, your lordship.
You are saying about state autonomy and other things.
Yes, your lordship.
What's the relevance?
The state has its own power to administer its own matters, your lordship.
Yes.
In the process of lawmaking, from introducing of a bill to passing of a bill or putting it to the assent of the governor, all the process of legislative competence falls under the administration of the state, your lordship. Here, having a governor who's solely selected by the union, if he infringes this question, your lordship, the state has no role to play in the process of its own administration, your lordship. And then,
Government does not take any administrative decisions.
your lordship, government plays a significant role in making sure that the laws made by the legislation is in line with the constitutional provision, your lordship.
Whatever may be the amendment or the replica of the old act, that does not mean that will be reduce the powers of the governor. Last occasion you have produced the several judgments as far as and other things are concerned. The Supreme Court very clearly held that in manner on which the governor being appointed as an agent of the state, that does not mean that he is the servant of the central government or otherwise the slave of the state government. He is not an informer. He is only a bridge, rightly you pointed out yesterday, he is only a bridge or a sandwich to communicate the day and date affairs of the state to the central government and to get assistance from the central government also. Now the learned brother wants to ascertain whether and on which 156 the governor being appointed, how they are, all the process of 156, 157, 150, everything has been by the new amendment, whether the states are affected or otherwise states' rights will be infringed. That is the question before you now, that you must answer for that.
Yes, your lordship. Your lordship, what we mean to say it affects the state autonomy is that, your lordship, the union plays the entire role in the process of appointment of judges, your lordship, appointment of governors, your lordship. So that the involvement and influence of the union is much more in the role played by the governor, your lordship. Thus, the chances or the
But that does not have anything to do with diminishing the powers of the state. Whether the governor is appointed with the president or from the persons nominated to the state legislative assembly, union cannot encroach upon the powers of the state. State cannot encroach upon the powers of the union. How does it even matter?
lordship, although the union cannot directly interfere or
Indirectly, they cannot encroach upon the powers of the state.
but your lordship, the governor has the power to assume the bill or withdraw the bill or reserve it for the consideration of the president, your lordship. Using this, it may hold or block the.
It may,
Yes, your
an
lordship.
apprehension you are before this court.
But your lordship, the factual matrix says that there are a lot of bills that is being pending, your lordship. This shows that the possibility is still the reality, your lordship. It may affect your lordship, but in the present case, it has affected your lordship. There are a lot of cases, lot of bills that is pending in the legislature, your lordship. This shows that the position of the office of the governors is not being utilized in the as per the constitutional mandate, your lordship. That is why we want to propose a system where this cannot be done, your lordship, where the office of the governor cannot be misused, your lordship. That is why we want the union and the.
What is the misuse?
Your lordship, as the proposition itself states, your lordship, several bills has been
You are dealing with the issue number 1.
Yes, your lordship.
You are dealing with the article 155 and the other things.
Yes, your lordship. Certainly, your lordship.
155 and other things speaks about only the appointment of the
Yes, your
governor.
lordship.
You are saying about the misuse of powers. Address the issue.
Certainly, Your Lordship. Your Lordship, I just wanted to answer the question that was proposed, Your Lordship. Moving on, Your Lordship, moving on, Your Lordship, the validity of 107 amendment is what is concerned, Your Lordship, as it involves both central and states participation in the process of appointing the head of the constitutional apex body of the state. So the question would be much more better, Your Lordship.
The question here is not whether 107 was valid or not. Now it has gone. 108 has come. Your argument should be whether 108 is unconstitutional or not. Restrict to that.
Constitutional Amendment 108 is unconstitutional because it takes away the position that was given, Your Lordship. As Constitutional Amendment 108 erodes the power, that is, it erodes the state representation part, Your Lordship, and then it also takes away the rights of the state.
The constitutional framers never wanted state to have a say in appointment of governors.
Your Lordship, although the state does not have that mandate, Your Lordship, the Constitutional Amendment 107 was introduced seeing the flaws in the mandate that was given, Your Lordship. That is why we wanted to propose, that is why the government wanted to propose such a amendment so that the flaws can be rectified and the question can be addressed even more better, Your Lordship. Coming to the unconstitutionality of the amendment 108, it erodes the concept of federalism by infringing the rights of state, Your Lordship. Moving on to the next argument, it violates the concept of cooperative federalism as well, Your Lordship. And as the recommendation of the
Quasi to cooperative federalism.
India follows a system of quasi and cooperative federalism, Your Lordship.
We have again touched the line. Please, when you use the term quasi-federal, please tell me what is the source. Quasi-federalism is not federalism. Quasi-federalism is unitary form of government like federalism, which is against your argument. Therefore, don't use the word quasi-federal. If you use the word quasi-federal, tell me what is the source of the expression.
The council will get back to the source of the word quasi-federal by the end of the argument, Your Lordship.
But if you use the term quasi-federal, we will dismiss this petition.
Certainly, Your Lordship. Your Lordship, I would like the attention of the bench to the recommendation of the Sarkaria Commission, Your Lordship. The Sarkaria Commission, which was appointed by the Parliament itself, Parliament only to address the interstate, to give recommendation on the interstate relationship, have given a few recommendations which was incorporated in the Constitutional Amendment 107, Your Lordship. But by nullifying the Constitutional Amendment 107, although there is no binding value to the recommendation, the standing commission, the Parliament standing commission's recommendation was ignored by the Union for its own sake, Your Lordship. Moving on to the next argument is the revival of political governorship, Your Lordship.
Political governorship.
Yes, Your Lordship. The Constitutional Amendment
If a governor is going to be appointed by the state legislature, then also comes politicization.
Your Lordship, but in the present case, the state government is not directly appointing, Your Lordship.
Yes.
Out of the candidates given by the president.
Only the 4 persons going to be nominated by the president.
Yes, Your Lordship.
There itself your autonomy, whatever you say, everything goes. Only the 4 persons who are going to be nominated, you are going to elect among the 4.
Your Lordship, the involvement of state.
You've seen cursory glance of Sarkaria Commission's report? No, you have not seen. It's only a replica of Justice Rajamanna's Commission's report.
Yes, Your Lordship.
1916 and the state government appointed.
Yes, that recommendation was ignored by the union government.
That is the best recommendation. The entire world appreciated it. What is the powers of the state and what is the powers of the central government, whether it can be called as a federal or a union, everything has been mentioned, how the judges can be appointed, what is the meaning of the recommendations of the council of ministers, how he can act, whether he's got a direct control or otherwise an indirect control, everything has been defined by Justice Rajamanna. It is only a replica of the Sarkaria's Commission report. You go through it thoroughly, then you will make it, or it is not necessary at all. As a student, you may not go into it thoroughly, but when you are pointing out that you must bear it in your mind, what is the crest of the issue, what is the recommendation of Justice Rajamanna and Justice Sarkaria? Please.
Yes, Your Lordship. As the in 1969, the Rajamanna's committee gave recommendation on the changes that has to be made in the Schedule 7 and the shifting position of the residuary powers from the union to the state, Your Lordship. But even that recommendation was ignored by the union government then, Your Lordship. Following which was the Sarkaria Commission, which came into existence in 1983 and it gave its report in 1988, Your Lordship. Would you like to submit the...
You can submit that. Only one thing. President is going to nominate 4% of his choice. There itself comes the politicization. You are going to elect only the one among the 4. What's your state autonomy or anything is going to do?
Your
You are
Lordship,
going to pick and choose among the 4 alone. It's not going to be a general election as in the case of president. It's not an open election. He is going to be nominated. That's what the amendment says.
Yes, Your
Amendment sound says. So among the 4, one person is going to be elected.
yes, Your Lordship.
So
But Your Lordship, giving the power to the center for entirely nominating, entirely appointing one person.
power to the president to nominate 4 persons.
Your-
What do you say further?
Your Lordship, this is to ensure that the union is involved and the state is involved, so the Congress
As in the case of president election, the governor election also has to go in the similar manner.
Your Lordship, even in the case of president's election, people are not, the candidates are nominated and indirect election is made from the House of Parliament and sorry,
In the president election, who are all being nominated? Just now you say someone is nominated.
the government nominates the,
Everywhere the politicization is going to be there. Even for the election of president, only the ruling party or someone opposition party is going to nominate a person. They have been elected by the state legislation along with the parliament. In this case, only the 4 persons elected by the president alone is going to be in the field. We have to pick and choose only one person.
yes, Your Lordship, certainly, Your Lordship, but Your Lordship, giving the state, the center, the whole authority to appoint the apex, that is the constitutional head.
Whole authority of the state comes here.
Your Lordship,
You are not having any authority over the election.
Your Lordship,
Only
it
the
gives
4th person is going to be nominated. You are going to elect one person. Where come if your state is going to be, there is no choice at all.
out of the 4, it enhances the concept of political accountability as well, Your Lordship. As the state only appoints the candidate, selects the governor through indirect election, and it also has the power to remove the governor through the process of impeachment that is followed for the president as well, Your Lordship. The political accountability, that is accountability of the governor is enhanced, Your Lordship. Entirely vesting the power of governor to the center, this the power that is being diluted to the state government is important in the present case, Your Lordship. That is why we want the participation of the state.
Yes, we appreciate you, but at the same time you have produced the Sarkaria Commission's report now. The Sarkaria Commission report says the appointment of the governor is concerned, it is the choice of the central government. The state government cannot do anything at all. It's a very word used by Justice Sarkaria is, he cannot be disturbed till 5 years is over. Rarely, in an extraneous circumstances, the state government may raise their voice to change, not to demit his office, to transfer. Yesterday also you appointed to Soundarajan, it's demitted her office to conduct in the election, and in the Pondicherry she has demitted her office unceremoniously. That is the rarest of rare things that you cannot be taken into cognizance at all. But the mandate of the Sarkaria Commission and the new amendment will affect the rights of the states. That you have not come to that point. You define that and go to the next point.
Yes, Your Lordship. Your Lordship, although Sarkari Commission gave the power to the central government, it also emphasizes on the importance of consulting with the Chief Minister in the process of appointment of Governor, Your Lordship. Thus, implementing that was the Constitutional Amendment 107, Your Lordship. As it was held in the case of State of West Bengal versus Union of India, the state government, it says that the constitutional process that directly impacts state governments, excluding states, undermines its constitutional status, Your Lordship. The case, it said that if it involves state governments, then excluding the state undermines its constitutional status was the rationale that it was observed in the Constitution.
Status of the state government is being undermined.
Yes, Your Lordship. Following the doctrine that was given in the case, Your Lordship, the Lordship, with this, I conclude the argument for issue 1, Your Lordship. Issue 2 and 3 will be determined by
Sure.
It was an honor being before this honorable court, Your Lordship.
The council seeks permission to approach the court.
Greetings to the bench. This is counsel 2 appearing on behalf of the petitioners. If I may continue.
Only for petitioner. You can seek the permission of the court.
Much
whether
obliged.
to argue or not.
Much obliged, Your Lordship. The council seeks permission to begin with the
Yes.
arguments. Your Lordship, before getting into the crux of issues 2 and 3, the council would like to satisfy the bench which was posed to my co-counsel with regards to
No
the
need.
issues. Much
That
obliged.
is issue number 1. You can proceed.
Much obliged, Your Lordship. Much obliged, Your Lordship. Your Lordship, issue 2 deals with the state amendment replacing the governor from the position of the chancellor of the state universities if it exceeds the constitutional standards, Your Lordship. Your Lordship, it is the humble submission of the petitioner that it does not exceed the constitutional standards and the state amendment is completely valid, Your Lordship. Your Lordship, with this, the council would like to argue on a 3-limb basis. The first sub-issue, which deals with the governor's role as a chancellor, is not a constitutional mandate, Your Lordship. Your Lordship, it is well understood and well accepted by the council that the powers of the governor cannot be touched upon. As also rightly pointed out by
The governor cannot be touched upon.
Your Lordship, the powers or the constitutional powers given to the governor cannot be restricted, as also held in the advisory opinion of the Supreme Court, Your Lordship.
The advisory opinion is binding this court.
It was a persuasive, it only has persuasive value, Your Lordship.
Then?
Your Lordship, even in that case,
We won't follow that.
indeed, Your Lordship,
We are
even
not
in
known to follow that.
Definitely, Your Lordship. It was an advisory opinion. It only has persuasive value, Your Lordship. Even in that particular case, Your Lordship, the chancellor is not the appointment of chancellor by the governor being the chancellor is not a constitutional mandate, and it is purely a statutory mandate, Your Lordship. And Your Lordship, it is to be noted that the practice of governor being a chancellor comes from an era of pre-independence, where the governor was said to be the chancellor for all universities, Your Lordship. It was followed directly in the same manner. But here, Your Lordship, in the constitutional drafters clearly stated that it was not a constitutional provision, mandatory provision, Your Lordship. And also, Your Lordship, in the committee report of Sarkaria report and in the Punchi report, it had held that the governor must focus on the constitutional responsibilities and avoiding statutory roles like the chancellor to preserve the dignity of the office, Your Lordship. Your Lordship,
If the chief minister or the education minister comes to the post, he will demean the dignity of that post.
indeed not, Your Lordship. The council will
What is the role of the governor in a university?
Your Lordship, the governor, if appointed as a chancellor, Your Lordship. Your Lordship, the chancellor will have the role to appoint the vice chancellor and also attend all the ceremonial.
Merely appointment of vice chancellors and issuing convocations. That's all.
Your Lordship, the
Can be done by the chief minister or the education minister.
which is exactly what the contention of the petitioners also, Your Lordship. It can be done by the chief minister and the educational minister. In that particular case, Your Lordship, the chief minister and educational minister will have more responsibility because they are also accountable for the people.
See, can you replace the expression governor with chief minister in the same line? The Punchi Commission on Center-State Relations recommended that you forget the commission.
Okay, indeed.
The governor should focus on constitutional responsibilities, avoiding statutory roles, right?
Indeed.
Even according to you, governor should have minimal role in the state scheme of execution, right? When the chief minister has bigger constitutional responsibilities, how can he look into all these things?
Indeed, yes, Your Lordship.
The logic suffers.
Your Lordship, only to answer that question, Your Lordship, I would like to point out the state amendment which was made in this particular case, Your Lordship, where the state amendment which stated that the chief minister or the shall be the chancellor of the university. He shall, virtue of his office, be head of the university and nominate the educational minister and also nominate the president of academic senate and shall present and preside at meetings of academic senate. Thereby, Your Lordship, it does not only confine to the purview of the prime minister or chief minister who will be the chancellor, but he also splits the power to the president of the academic senate.
My only question is that Your apprehension is that constitutional responsibilities are bigger.
Indeed, yes, Lord.
When the Chief Minister or the Education Minister have bigger constitutional responsibilities, how can they focus on all these things? So,
Which is why there is appointment of President of Academic Senate, Your Lordship. Lordship, it is very well understood both are important positions and the governor has a constitutional, he has a constitutional mandate to follow and so has the Chief Minister. The only difference between the switch of roles is, Your Lordship, one is that the governor does not have any political responsibility or is not reportable to the public. The Chief Minister or the Educational Minister here is reportable to the public. Thereby, the governance of the university will only exceed and will not diminish. Your Lordship, here when we talk about the appointment of Vice Chancellor, Your Lordship, there are several universities which lack in the appointment of Vice Chancellors, Your Lordship, when they are in the administration of the governors. Your Lordship, only to solve all these hurdles and to have a better governance and only to make sure that the governors also have a responsibility put on to them is why we are proposing an amendment which has the Chief Minister or the Educational Minister as the Chancellor and not the Governor, Your Lordship. It only builds the responsibility of the government, Your Lordship.
For your question, you have circulated the Commission's report, what is the central and the state government relationship. You read 5, 6, 11 for a moment. For your questions, the answer for that also. You read it once again or otherwise I read it. 5, 4, 5, 11, you kindly see that. Governor or Chancellor of universities. It states an important question which arises with respect to the governor is whether he should have any role in the administration of education in a state. Next one, the question arises because the governor are routinely appointed as a chancellor by the central government. Next line is concerned. Although there have been no judicial pronouncements that deal with the implications of visiting the sort of a power with the chancellor, there have been cases in the spelling purposes that the capacity of the chancellor of the university, the governor acts in his directions and not on the aid and advice of the council of ministers.
Indeed, yes, Your
This
Lordship.
is a correct answer to your question. Though the governor has been appointed by the central government in a routine fashion or routine manner, that does not mean that they can act independently. On the
yes.
advice of the council of a minister, they are acting. But in the practical, there is no judicial pronouncements, but the governors are acting independently. How you get over it?
Indeed,
Answer.
yes. Indeed, yes, Your Lordship. To substantiate the same, the Council would also like to refer to Article 163, which talks about the Council of Ministers and aid and advice of the minister, where it says that the governor can act on his own discretion only when the Constitution mandates. Now, when the position of the Chancellor is not a constitutional mandate, Your Lordship, here the governor cannot act independently.
You cannot say that in the constitution. It is you can act as a railroad, the governor and as a chancellor.
Indeed, yes, Your Lordship, but the discretion to act independently.
Whether the vice chancellor post can be that is also that also appointed by the governor. That is the question now. Changing of the post from the chancellor as a governor, that is the secondary option of the government, state government. First option of the government is concerned whether the vice chancellor also can be appointed by the governor. We can act in a dual role. That you must answer.
Indeed, yes, Your Lordship. Your Lordship, the UGC regulation which says that a vice chancellor can be appointed without the discretion of the Council of Ministers. Your Lordship, it is a UGC regulation. We can take it as a UGC Act. We can take it as a statutory regulation. Your Lordship, there are two limbs.
State universities are bound by the UGC regulation.
Indeed not, Your Lordship, which is my argument here. Indeed not, Your Lordship, unless they are specifically adopted. And Your Lordship, to this the Council would like to...
What about the public?
Indeed, yes, Your Lordship, with regards to the repugnancy, the Council like to state about the concurrent list and the state list. Your Lordship, education comes under the concurrent list, entry number 63, Your Lordship, but the administrator of the universities will come under the state list, Your Lordship.
The word administration of universities is mentioned in the...
Indeed, yes, Your Lordship, the Council would like to refer to the entry number 32 of the state list.
What does it say?
Indeed, yes.
Whether that word administration is there?
The creation, insolvency and the administrator of the institutions. Yes, Your Lordship. incorporation, regulation and winding up of cooperation other than those listed in list 1 and universities, incorporated trading, literary, scientific,
From that
religious.
administration word comes there.
Your Lordship, the
Incorporation is different.
regulation and winding up.
Regulation is different.
Your Lordship, the regulation concept will also apply for the administrative purpose, Your Lordship. Your Lordship, only for that sake we have state university acts, Your Lordship. Your Lordship, the council would like to provide the bench with 5 state university acts which has already which stated that the appointment of the governor, the chancellor shall be the governor, Your Lordship. Thereby, Your Lordship, the administrator of the state by the State University Act gave the governor the power to be the chancellor, Your Lordship. Now, it is well within the powers of the state government to pass an amendment changing the chancellor to be the chief minister or the education minister, Your Lordship.
What is the recent development on that?
Your Lordship, we had passed the bill in the legislation, Your Lordship, and it went to the governor, and the governor did not give assent, Your Lordship. Then the state government had approached the High Court and we received the deemed assent, Your Lordship. Though it was nullified in the advisory opinion, Your Lordship, as Your Lordship rightly pointed out, it is in the persuasive.
I'm sorry, Supreme Court never nullified.
It never nullified, Your Lordship, which only favors us saying the bill had passed, Your Lordship.
But all of you in your team, when you are making our submissions, you are using expressions that can be used against you.
Your Lordship, it is just to make sure that we are aware, even in the worst case scenario, it favors us, Your Lordship.
Court decided the issue on only one fold, on whether the governor has got the powers to keep the bill pending in his table. That's what Supreme Court originally said, he can, but how long, that is the question.
Indeed, yes, Your Lordship.
Yes, that is the question before. Reasonable time has been fixed by the Supreme Court. This is Paldiwala and Mahadevan has held, it is ultra violence and the constitutional mandate is violated, so he cannot keep the matter pending ever last. That is the order. Then subsequently the full bench now says, no, that we will decide the issue. Then subsequently they have said, the earlier order will not nullify the issue. The governor's powers are limited, but how long it be the question, that we will decide later on. That you cannot say now the powers of the state government was brought to the governor or otherwise selecting the governor by the chief minister or the council of ministers are good. That you must confine your argument to that.
Indeed, yes, Your Lordship. Your Lordship, with respect to the arguments which relates to the time period which was fixed to the assent of the bill, the council will be dealing with in the next issue, Your Lordship. With respect
What may learn to do is
much obliged, Your Lordship. Your Lordship, for repugnancy, the council would like to state the case of M. Karnataka vs. Union of India, which had stated the elements of to satisfy the doctrine of repugnancy. Indeed, yes, Your Lordship. Even
you are before the Supreme Court.
apologies, Your Lordship.
With the facts and law.
Apologies, Your Lordship. Your Lordship, there is no repugnancy in this particular case because the UGC regulations, it's itself invalid, Your Lordship, because they is invalid. Your Lordship, because with respect to the administration and appointment of Vice Chancellor, it will come to the purview of the state government and it falls into the state.
Have you challenged the provision here?
Your Lordship,
You can't come to the conclusion that the UGC regulation is invalid. That is for us to decide.
Your Lordship, the UGC regulation then cannot be adopted by the state government, Your Lordship. And according to the case of Kalyani Mathivanan,
You derive the power out of the UGC regulations for enacting the regulations there.
Your Lordship, it was held by the Honorable Supreme Court in the case of Kalyani Mathivanan versus K.V. Jayaraj.
Has been overruled.
Your Lordship,
That's also been overruled. What your station? Kalyani has been overruled.
Your Lordship, this was...
Maybe don't put the overruled then.
Apologies, Your Lordship. Even in that case, Your Lordship, it comes into the purview of the state
You
legislature.
are quoting that overruled then.
Apologies, Your Lordship. The council will refrain from quoting the overruled judgments. The council will...
You don't work out research. You do research or not?
Indeed,
Why
yes.
are you quoting the overruled?
Your Lordship, that was only to have a persuasive value of how the
Why are you putting the overruled judgment?
council apologizes, Your Lordship. Your Lordship, it was only the judgment was only stated to have the understanding of the then bench.
The overruled judgments.
The council will refrain from quoting overruled judgments, Your Lordship. Much obliged, Your Lordship. Your Lordship, with the answer of the question of the repugnancy, Your Lordship, the council would like to state that the amendment which was passed by the state...
Two judgments which has been overruled.
The council will duly refrain from quoting overruled judgments in turn. Your Lordship, the doctrine of repugnancy comes when there are two inconsistent laws and from the state government and the union government. And in that particular case, the union government laws will prevail. Your Lordship, in this particular case, the UGC regulation was passed with respect to the appointment of vice chancellor. The state amendment was passed of who will be the chancellor. Your Lordship, thereby there is no inconsistency. And
UGC says the governor chancellor. Now you are state amendment, you are saying that chief minister will replace the...
Your Lordship, there is no...
clear case of overlapping.
Your Lordship, there is no clear stand. It says that in the UGC rules itself it states.
There is an inconsistency, there is a conflict here, and which one would prevail, you have to answer which is going to prevail.
Your Lordship,
The conflict is inconsistency.
indeed, yes, Your Lordship. Your Lordship, even in the case of inconsistency, the council had to present that since the matter comes under the purview of the state government and since the UGC regulations are not specifically adopted by the state government, the State University Act will prevail here, Your Lordship. If you're...
That's what I'm saying. The State University Act has been derived from the power of university.
Indeed, yes, Your Lordship. Your Lordship, even in that particular case, the doctrine of repugnancy will only come to play when the matter falls under the concurrent list, Your Lordship. When the matter itself falls under the state list, Your Lordship, the state, even though the powers are derived from the UGC regulations, since the matter is in purview with the state list, it will
You are saying that education does not fall with the central.
Your Lordship, the education and the standards of education very well falls under the concurrent list, Your Lordship. But when it comes to the regulation and the administrative part, Your Lordship, it falls under the state list, Your Lordship. There are only 3 exceptions, Your Lordship.
Brother asked the specific question.
Indeed, yes.
Whether you would challenge the UGC regulations. That is not under challenge.
Your Lordship,
There is a law enacted by the central government, UGC Act. You had adopted that. But you are enacting a separate law by way of an amendment.
That is inconsistent.
indeed, yes. Your Lordship, to answer that, Your Lordship, the UGC regulation is released for the uniformity of all university, including central university and state universities, Your Lordship. Your Lordship, here the council seeks permission for an extension to complete the act. Your Lordship, here the council is not challenging the entirety of UGC regulation because the state government has not adopted it, Your Lordship. The other states and central universities can adopt the UGC regulations, Your Lordship. But this particular state government, since you have not adopted it and since you are not bound to adopt it,
You say that you have not adopted. Is it given in the proposition?
Your Lordship, we have Your Lordship, to adopt, the states are specifically supposed to adopt the regulation, Your Lordship. Specifically adopt.
They are adopted or not?
Your Lordship, the current.
Under from the facts. Proposition.
Indeed, yes, Your Lordship.
Your co-counsel has mentioned some para number 5, I think. Page number
Indeed, yes, Your Lordship. In page number 5, para number 6, Your Lordship, the State Assembly of Tamil Nadu made an amendment in the provision of the state university.
Conveniently avoiding the previous paragraph.
Your Lordship, yes, Your Lordship, with respect to the span of a month, was adopted within a span of a month. But Your Lordship, it was not clear that whether the state governments have adopted it. UGC regulation also applied to all the central universities, Your Lordship. Thereby, Your Lordship,
UGC will apply only to the central university.
Your Lordship, UGC will apply to all the central universities and the state university can adopt it, Your Lordship. It is under their purview, Your Lordship. In this particular case, since this amendment was passed inconsistent, as rightly pointed out by the bench, since it is inconsistent, it can be inferred that it was not adopted by the current state government, Your Lordship.
So you produced now the Paraviyar University Act, Anna University Act, and the external government gazette, and other things are concerned.
Indeed, yes.
It depends only the powers of the government.
Indeed, yes, Your Lordship. Your Lordship, this is to substantiate the fact that the powers of the government.
Why you have produced all these things, how that can strengthen your case?
Much obliged, Your Lordship. Thank you for the question. Your Lordship, it was only produced to make sure to substantiate on the point that the powers of the governor with respect to being the chancellor comes from the statutory body, Your Lordship. It does not come from any constitutional mandate. Thereby, it is under the purview of the state government to also make an amendment to change it, Your Lordship. Only only to substantiate on that point, the council had presented with the act.
So you can control your order.
Much obliged, Your Lordship. Your Lordship,
you can second over time also.
much obliged.
Third, you go to the third issue.
Much obliged, Your Lordship.
There is a dynamics water or not?
Much obliged, Your Lordship. The council will stick to the granted time. Your Lordship, the third issue deals with the constitutional amendment all by Article 200, Your Lordship. Your Lordship, this particular article, Your Lordship, it had inserted a provision which says that provided on withholding the bill for more than 6 months by the governor, the bill shall be automatically transferred to the President, Your Lordship, and for the consultation of the President, and shall not be bound by the aid and advice of the Council of Ministers of the Union. Your Lordship, though in the surface level it seems to be an provision which is too good to be true to maintain all the unbiasedness of the Union government, Your Lordship. Your Lordship, if we look from the constitutional drafter's purview, Your Lordship, there are two limbs to this, Your Lordship. One is that they specifically did not want Article 200 and 201 to have any tenure mentioned, Your Lordship. They did not want a specific time bounded by the to bound the governors or the President, Your Lordship, which was violated here with the 6 months period.
So providing a reasonable time of 6 months, it's validity.
Your Lordship,
Your governor can sit upon the bill.
indeed not, Your Lordship.
Your Lordship, the state government will in no way will accept the argument that the governor can sit upon the bill, Your Lordship, considering these are the ones who filed the case of state of Tamil Nadu.
Therefore, you cannot use that point against you.
Your Lordship,
Your submission should be in six months' time should be valid, but sending it to the president and him sitting upon for a very long time
indeed
is
yes, Your
wrong.
Lordship. That was the second.
Doesn't have a bill, so 201 is for consideration.
Indeed, yes, Your
That
Lordship.
question before the Supreme Court now.
Indeed.
How long? That yes.
Indeed, yes, Your Lordship. Your Lordship, the second limb was it the automatic transfer, Your Lordship. Your Lordship, this automatic transfer falls under the arbitrary provisions, Your Lordship. Your Lordship, if you do look into the original Article 200, Your Lordship, the bill can be sent to the President only if it erodes the powers of the concerned High Court. Now, Your Lordship, sending it directly, just because it stands for 6 months period, sending it to the President automatically only enhances the pocket.
You understood your subject, both of you are very excellent in place. Who is the governor, how can be appointed, how long is the tenure of his office, and what is the powers of the governor, whether he can keep the bill pending ever lost, or whether what is the Supreme Court amendment, and what is the state amendment and state enactment, and what is the report of the Secretary, and the Rajamanna Commission. Very good, excessive days, you conclude your argument. Finish.
Much obliged, Your Lordship. Your Lordship, the
Prayer, come to prayer.
Your Lordship,
Therefore, in the light of issues raised, arguments advanced and authority cited, it is most humbly paid before this honorable court to declare that the constitutional amendment 108, which nullifies the constitutional 107, is not valid, and affirm that the state amendment which was passed to replace the governor from the position of chancellor and appoint chief minister or the education minister as a chancellor is valid, and to declare that the constitutional amendment 200 is invalid, Your Lordship. And for this act of and pass any other order that this honorable court may deem fit in the proper circumstances of this
Pass
case.
order, not any other order, don't use the word.
Pass orders
in the proper circumstances of this particular case, and for this act of kindness, the counsel for the petitioners will be duty bound and forever free. It was an honor. Much obliged.
What you say for the third prayer, you want to declare the Constitution 109th of...
Invalid, Your Lordship. It was a typological error, Your Lordship.
Something is written in our...
In the oral submission, we did mention it was an invalid, Your Lordship. That was a typological, the counsel.
Yes, proceed.
And
Material consequences.
Good.
Your Lordship, with respect to the argument of quasi-federalism where we derived it, Your
No
Lordship.
need for further...
There is
Your co-counsel has already
also we have
elaborated.
said that the state also are very keen on that subject, whether the federal or union. So that we should not go into the conflict any.
Indeed, yes, the council wanted to present state of West Bengal versus Union.
Okay.
Definitely not, Your Lordship. The council will take it into due consideration and will never reply.
Like, make sure that we have to stand for good. Both
Indeed,
is
yes. Will duly noted, Your Lordship, will not.
The council seeks permission to approve the diary. Much obliged, my lord.
Counsel, no need for facts. You can straight away go to the issues. What are being placed?
Much obliged, my lord. Warm greetings to the bench. Myself, counsel for the respondent dealing with issue number 1, and my co-counsel will deal with issue number 2 and 3, and researcher will help us during our proceeding, my lordship. Much obliged, my lordship. My lordship, the council seeks permission to move on to issue number 1.
Yes.
Much obliged, my lordship. My lordship, the issue number 1 deals with whether the Constitutional 108th Amendment Act 2025 nullifying the Constitutional 107th Amendment Act 2020 is valid. My lordship, here the counsel for the respondent most humbly submits that the 108th constitutional amendment that is called valid amendment, my lordship, because my lordship under article 368, which expressly empowers the parliament to amend the constitution by way of addition, variation or repeal, my lordships. And my lordship, this power to amend the constitution is continuing in nature. No previous amendment can make immunity over the amendment, my
No,
lordship.
about the 368 and all.
Much obliged, my lordship.
Directly answer to their question. Whether it affects the basic.
Indeed, no, my lordship does not affect the basic structure, my lordship. My lordship, I would like to show the intent of the framers of the constitution for making the appointment over under article 155, my lordships. My lordship, during constituent assembly debate, there has been four models which has been discussed for appointing the governor, my lordship. Firstly, it is by election that the governor is being appointed directly elected by the people, and the second model is election by the state legislature, and the third model is election, the nomination by the president from a state panel.
See, counsel, we understand all that, but all of them have been out of practical experience and after comprehensive consultative process, it was deemed necessary that 107 had to be brought.
Much obliged.
See, today we have 109th amendment according to our MOOT proposition,
Indeed.
which means whatever original framework of the constitution thought was not static. Constitution is an organic document. Therefore, after comprehensive consultative process, 107 was brought. You get into the power, within 1 month you change it to reverse it. So, the manner in which you have brought about this amendment is questionable. Is that not arbitrary?
My lordship, here the governor's neutrality, in order to preserve the neutrality of the governor, he must be he must not be given
He must be someone who will be toyed by the union government.
Indeed, no, my lordship, he is not toyed by the union government. My lordship, it was already stated in the case of Rameshwar Prasad versus Union of India, cited 2006 to LCC 1, where this honorable court held that the governor is not an agent or an employee under the government of India, my lordship.
So therefore, when he acts like an agent, Parliament thought it fit to make the amendment. 107th amendment was brought.
Indeed, no, my lordship, here the 107th Constitutional Amendment Act is trying to make the governor to be a puppet of the state government, my lordship. By
It does not diminish the power of the governor and enhance the power of the governor. How will we puppet of the state government?
Indeed, no, my lordship, if the governor has been appointed by the state legislature or he has been removed by a state initiative.
Elected from one among the persons nominated by the president.
Much obliged, my lordships. My lordships, here the constitutional infirmity lies on not who nominates the person. It lies on who has democratically electing the governor, my lordship. If the governor has been elected directly by
Democracy in this election. Under 108th amendment, where is the democracy?
my lordship, here the state legislature is the persons who are representative of the people. So here it
Among
is.
the four, that's what he is saying.
My lordship,
Among the four, you are going to elect one.
much obliged, my lordship.
Then where is the democracy?
My lordship, here the election by the state legislature is considered to be the people's will, my lordship. So it is considered to be democratically elected person. Much obliged, my lordship.
You mean to say that the governor is merely a representative of the central government and he is not acting on his own, like he is not acting neutral, that is your case?
Indeed, my lordship, he is.
How do you substantiate on that? What is your substantiation on that? How do you substantiate on your claim?
My lordship, by citing the previous judgments of Rameshwar Prasad versus Union of India, it was held that the governor to be a neutral person, my lordship. The question of the governor has been designed as a linchpin of the federal government.
Made a political paint on this.
Pardon, Your Honor.
What do you mean by political paint on the problem?
My lordship, we didn't make any political paint on the governor. My lordship,
You said that governor will be a puppet of the state government. Is there not giving political color to the governor position?
my lordship, no, indeed no, my lordship, by directly appointing the governor through state legislature, removing him through the state initiated removal procedure.
If we take your submission that as of 107th amendment, if the governor is appointed, he will be a puppet of the state government. Then according to 108, he will be a puppet of the union government.
My lordship, I would like to cite the pleasure of the doctrine of the president to my lordship. President, my lordship, pleasure of the president doctrine.
You have produced the judgment Rameshwaram, have you gone through it thoroughly?
Indeed, my lordship.
Yes. What is the substance of the issue?
My lordship.
Justice Balakrishnan Sabharwal passed his order. What is the substance of this issue? What is the governor's role has been, what is the power of the governor, how it was defined by the Supreme Court? You have produced the judgment now.
Indeed, my lordship.
What is the content of it?
My lordship, here the governor, in Rameshwar Prasad case, the governor should be a neutral constitutional head where he is not an employee of the union government. That has been substantiated in that case, my lordship.
That is not only the word used by the Supreme Court. He said he is only a philosopher, he is a
also a
guide,
guide,
he is a
friend,
friend.
my lordship.
Yes, I will finish it, madam. Wait.
Much obliged, my
He is a
lordship.
philosopher, guide, friend, and he must
Madam,
respect
yes.
the constitution.
Much obliged,
You please, madam.
Indeed, my
You
lordship.
respect his, he must respect his conscience and act accordingly on the advice of the ministers of council. That is the word. So it says, right, you have pointed out, he can be act as only a friend of the, though he was appointed by the central government, the Supreme Court
acts
is
only on
about
the aid
Justice
and advice of
Balakrishnan
the
has said, he can act upon the advice of the council of ministers. Come on, you produce.
Much obliged, my lordship. My lordship, moving on to the pleasure of the president. My lordship, in submitting the case of D.P. Sinhal versus Union of India, cited 2010 6 SCC 331, where this honorable court has clarified that for removal of the governor, there should be some rare and compelling reason, my lordship. He cannot be removed in an arbitrary manner. So, my lordship, here the judiciary itself has provided with proper scrutiny over the arbitrary removal of the governor, which mandated there is no need for the 107th Constitutional Amendment Act for proceduralizing the removal of the governor to state-initiated removal, my lordship.
They are now introducing a constitutional mechanism for the removal of the governor. You say that the courts will take care. Then what's for the fun in having this
My
constitution?
lordship, much obliged, my lordship. My lordship, here the pleasure of the need for the pleasure of the doctrine is pleasure of the president. Much obliged, my lordship. I'm really sorry for it. My lordship, here the pleasure of the president, the governor holding the power under the pleasure of the president is only to when the governor has acted in an unconstitutional manner against public morality. He can be.
You say that everything is subject to this judicial scrutiny. Whether the courts are going to rule the country?
Indeed, no, my lordship. But here the judiciary has provided with some remedial measures
So
for
you
the.
mean to say that whatever thing will let that happen, the judiciary will take care?
Indeed, no, my lordship. Here the 107th amendment is an unnecessary one here, my lordship, because
No,
the
in all these circumstances we step in because there's a vacuum in the constitution. Now that vacuum is filled with the 107th amendment. You are saying that you need not fill the vacuum because judiciary will take care of all those judicial review matters. Wherever there is a vacuum, they will step in.
my
But we
lordship.
have better things to do.
Indeed, no, my lordship. Here state-initiated removal will make the governor to be a vassal of the state legislature, my lordship. So here 107 cannot be validated, my lordship, since the judiciary itself has provided proper measures to prevent the arbitrary removal of the governor, my lordship. Much obliged, my lordships. My lordship, moving on to insertion of Article 158, Clause 1A. My lordship, here the 107th Amendment Act has created a class legislation because it has inserted two provisions, my lordship, for disqualifying a person. In order to be a governor, the person should not be member of either the parliament or the state legislature at any time. My lordship, this at any time is creating a class legislation, my lordship, in which lacks the intelligible differential as well as the rational sexes, which must be satisfied under Article 14. My lordship, thereby citing the case of DHANAPALAN versus Union of India, cited 2017 9 SCC 1, where this honorable court has held that any legislative action which is capricious.
No, you go through it first. You produce these judgments equal. You support this judgment or you would like to agitate it. If you want to support this, you continue your argument to supporting this judgment. What this judgment says? Justice Rebuttals passed this order.
My lordship,
How do you substantiate this?
much obliged,
When you produce this, you say whether it is correct or wrong.
my lordship, here the 107th Amendment Act is lacking the intelligible differential and rational nexus, my lordship, which is against the doctrine of.
This judgment is very clear. 156(1), what is the power of the president to remove the governor from the post? It cannot be under the federal setup. It cannot. But at the same time, the rarest of rare cases, they can be removed. See, that is the substance of this issue.
Much
Then another judgment that we have produced, what is that?
Shaira Banu.
Yes.
Much obliged, my lordship.
Come on, you're on.
Much obliged, my lordships. In this Shaira Banu versus Union of India, it was held that any legislative action which is capricious, irrational and lacks a logical basis is against the doctrine of manifest arbitrariness under
Sir,
Article
okay.
14.
In what way it is affecting the 158 1A? You started with...
Much obliged, my lordship. My lordship, Article 158 1A has inserted two provision which states that in order to be a governor, he should not be a member of parliament or a state legislature at any time, my lordship.
Yes.
This term at any time, which is extraordinary situation, my lordship, which lacks the intelligible differentia here.
What is that intelligible?
My lordship, the person who should not, if in case this
The
amendment
person
should be
without a
like,
political knowledge has to be appointed.
my lordship, for the sake of argument, I would like to say that if the amendment is like the governor should not be a member of either a member of parliament or a state legislature for a particular time period is a reasonable one. But here it is stating that at any
The person
time he
going
should
to
not
rule
be.
the government, the state government, being a governor, whether he has to know about the functioning of the state legislature or the member of the parliament or the central house.
Begging your pardon, I can't get a question.
My question is, a person, if he is going to be a person in the state legislature or in the parliament, he will alone get the facts and the functioning of the parliament and other things. You are saying that the person who holds the post cannot be appointed as a governor.
My lordship, my contention is that here, being a member of parliament or state legislature, any time that the qualification which is prescribed here is considered to be extraordinary and it is arbitrary, my lordship.
See, you're frequently using the word intelligible and rational. What is the difference?
Much obliged, my lordship. My lordship, difference here, which means that there should be some which must accept the rational nexus of the case. That is the objective of the legislation here. But here, my lordship, creating the term at any time, he should not be a member
Class
of.
of person. Governor is a class of person.
My lordship,
Intelligible differentiate.
indeed,
You have to differentiate from one person to another person.
much obliged, my lordship.
It's a group of persons, okay? That the governor is ceremonially opposed to, where is the class of person coming here?
My lordship, the class of person here, which means that the person, he creates a second class citizenship, that the person should not be either politically active before this.
Where does the intelligible differentiate come here?
My lordship.
That's the intelligible differentiate. See, for intelligible differentiate, you have to distinguish between persons, between the class. One person like it, one person like it.
Indeed, my
And
lordship.
there should be a rational decision.
Indeed, my lordship, which was aligned with the legislation.
Then, there's no relevance at all. There is no relevance in your point for
Indeed,
insisting the point on intelligible rational.
my lordship, here the intelligible difference, why I say the intelligible differential lacks here is because it creating a separate group of people beyond that. My lordship, because it completely excludes the.
My friend is asking in what way it is connected to your claim which you are making right now. In what way it is connected, the term which you are coining.
Much obliged, my lordship.
Don't you see, intelligible differentiate and the rational or group of people, for land acquisition, they use intelligible,
Indeed, my lordship.
not for government.
But my lordship,
For land acquisition, Article 14 can use this, but not for the monarchy.
but my lordship,
That's
here,
the class of persons. Where is that? Who's the class of persons?
my lordship, the persons who are not a member of parliament at any time or
What distinction are you trying to make here? What is the distinguishing?
My lord,
How you are
here-
distinguishing it? How you are distinguishing it and what distinction you are trying to make?
What's saying about the gentleman says?
the Shaira Banu versus Union of India. Much obliged, my lordship. Indeed, my lordship, in that it says that any legislative action which is capricious, irrational and lacks a logic against the doctrine of, indeed, my lordship.
Is said to be overruled, this since overruled. Another wants to know what is this content of issue. Only Article 14 has been discussed in the case. Only Article 14 has been discussed.
That says because the women have been differentiated there. It's a class of persons.
Indeed, my lordship.
What is the matter?
My lordship,
It's about power.
indeed, my lordship, Shaira Banu.
There is a class of persons which has been differentiated. That the governor has been differentiated.
Much obliged, my lordship. My lordship, here the classification is arbitrary, which may that at the term at any time, which makes the governor candidate already a political person who can be a governor. They cannot be a governor, my lordship. So it is separating the person who.
Yeah, that's the group of persons. That is the problem.
My lordship, the group of person is the one who has already participated in the politics, actively participated in the politics earlier, my lordship. It is entirely disqualifying them from being a governor. So this is the class legislation I am trying to substantiate here, my lordships. The bench.
But one thing is, like, you're saying that you should not have any political background. How a governor will be able to operate without a political background? He should not be a part of any political party, he should not represent a political party. But are you trying to say that you should not have any political background?
My lordship, our contention is not that
you made that claim now. You're saying that you should not have any political background.
That has been brought through 107th Constitutional Amendment Act, my lordship, which.
My viewpoint is that you should not be a part of any political party, you should not represent the political party. But without a political background, how can a governor operate?
My lordship, the 107th Constitutional Amendment Act has brought that, my lordship. Our contention is that our contention is that not that, my lordship. Here we are trying to disqualify the 108th Constitutional Amendment that they has brought. Much obliged, my lordships. My lordships, and moving on to this legislation has been considered to be a democratic mandate of constitutional reversal, my lordship.
Moving on, that should move up.
My lordship.
Both of you are saying moving on. That should be moved.
Further arguments. Much obliged, my lordships. My lordship, here the 108th Constitutional Amendment is considered to be a strongly a democratical mandate because the National Conservative Alliance, which has brought this 108th Constitutional Amendment, has won around 350 seats, my lordship, which satisfies the 2/3 of the majority to pass a legislation. So here the 108th Constitutional Amendment is considered to be a valid amendment, my lordships. If the bench permits, the council would call upon the co-council to deal with issue number 2. Much obliged, my lordship. It's very honored to argue before this bench.
Council seeks permission to seek the rights.
Yes, sure.
Much obliged, your lordships. I am counsel representing on behalf of the respondents and I will be dealing with issues number 2 and 3, your lordships. Your lordships, issue number 2.
Whether the state amendment replacing the governor from the position of chancellor of state universities exceeds constitutional standards and limits. Your lordship, indeed it exceeds constitutional standards and limits because, your lordship, it's very clear from the threshold of the constitutional scheme that under entry 66 of list 1 in the 7th schedule of the Indian Constitution, it is stated coordination and determination of standards in higher education exclusively confer legislative domain only to the union. Though education is a concurrent list, your lordships, under entry 25 of list 3 as contended by the petitioner council, this power of the union acts as a constitutional ceiling over states' legislative competence, your lordship. And also the petitioner council refer to entry 32 of the list 2, your lordship, and referring to article 246 subclause 1, 246 subclause 2 and 3, it is clearly mentioned that the state's power under the state list is subject to the union's power, which means that in case of conflict between union and the state law, the union law is bound to prevail. And the same was held by this honorable court in the case of State of Tamil Nadu versus Adiyaman Educational Research Institute, 1995 4 SCC 104, which the council humbly supplies. Educational and Research Institute, your lordships. Your lordships, this supremacy is also textually enforced in the constitution itself, your lordships. And in entry 25, the concurrent list itself, it is provided that it is subject to the entries 63 to 66 of the list 1, your lordships. And also in more recently, in the case of state of West Bengal versus Anindya Sundardas.
Adiyaman College of Engineering is not only a caution to the government, it is a caution to the persons who are running the institutions also.
Your lordship.
This is the judgment of the Supreme Court, Adiyaman College of Engineering, the Supreme Court held how the institutions also must be run.
Indeed, your
So
lordship.
in the cathedral college should not be run. What will thoroughly the constitutional issue that you are raising in, we appreciate you, but rest of the issues also canvassed in the
Indeed, your
order by the
lordship.
Supreme Court, the Adiyaman College of Engineering.
Indeed, your lordship.
You carry on.
And more recently, your lordships, in the state of West Bengal versus Anindya Sundardas, 2023, 1 SCC 313,
the court held that the state cannot bypass the chancellor or amend its laws to override mandatory UGC regulations, and emphasizing that vice chancellor appointments must conform to the standards specified under entry 66, your lordships. Your lordships, further the council submits that UGC regulations framed under the UGC Act are mandatory national benchmarks, your lordships, and they cannot be simply overruled by any legislative or executive action of the state, your lordships. And the petitioner counsel quoted the Kalyani Madhivanan case, which was already overruled under the case of Professor Srijit PS versus Dr. Rajeshri MS, where it was held that any deviation from the UGC norms is unsustainable in law, your lordships. And also, any state action which is diluting this power and excessive discretion is conferred on the political executive falls with repugnancy. And also, your lordships, in a very recent case, the Honorable Supreme Court on Jan 30 to 2026, in the case of Dr. S. Mohan versus Secretary to the Chancellor, Puducherry Technological University, held that UGC regulations, though not adopted by the state, are to be mandatory followed by the state. As the same was held in the case of Professor Srijit PS versus Dr. Rajeshri MS.
Come on, okay.
Your lordships, therefore, my lords, the states may supplement national standards, but they cannot override or dismantle them, and it ensures uniformity and academic autonomy in higher education only by following the UGC regulations, my lords. And your lords, means that the term expression used in standards in entry 66 includes not only syllabi and infrastructure, your lordships. The vice chancellor is not only the ceremonial head, he is the academic head, the chief executive, and the guardian of the institutional autonomy, your lordships, which means it
Here the question is about the chancellor. See, even whether the chancellor is the governor or the chief minister or education minister, while nominating or appointing the vice chancellor, they are only going to stick on to the standards that are fixed by the UGC regulations.
Indeed, your lordships, but the state amendments here tend to replace the governor with the chief minister or the educational
How is that relevant?
And that person who is acting as a chancellor will be appointing the vice chancellor, your lordships.
Not arbitrarily.
Your lordships?
Not arbitrarily. There will be whoever sits as a chancellor.
Indeed.
They are bound by the rules and regulations stipulating the qualifications and standards with respect to appointment of vice chancellors.
Indeed, your lordships. Because I am substantiating this argument by stating that the union has the power to bring UGC regulations and that they are valid.
Absolutely they have. But who is appointed as a chancellor, whether the governor or the chief minister, has nothing to do with standard of education is what I am saying. How do you connect that with this? What is the rational nexus?
Your lordship, because the person acting as a chancellor will appoint the vice chancellor, who will determine that?
You the same answer. The vice chancellor is appointed only within the framework of the rules and regulations. If the vice chancellor, if the CM or the governor is going to be the vice chancellor, then they affect the minimum standard according to your argument. But chancellor, whoever it is only going to appoint or select a vice chancellor within the framework of the qualifications, rules and regulations with respect to appointment of vice chancellors, which affects the standards.
Your lordships, I would like to quote the case of Gambardhan K. Gargi versus State of Gujarat. Indeed, your lordship. I only substantiated that argument to prove that union has legislative competence, your lordships. And actually,
We are not on the legislative competence at all.
your lordships, I mean to say that UGC regulations are binding on the states, and because they have enacted state amendments which are in violation of such UGC regulations, and trying to prove that the state amendments are invalid, your lordships. And only for the same contention I quoted this point.
So you produce the judgment now. The Professor Rajeshri has been only a candidate has been sent the post of the Vice Chancellor.
Indeed, your lordship.
Yes. I have gone to this judgment.
Indeed, your lordship.
Yes. See, what is the arbitrariness? At least the 4 persons then should be recommended
Indeed.
for the post of Vice Chancellor. But in this case, only 1 person name has been recommended for the post. That was challenged, the Supreme Court said no, it is arbitrary.
Indeed, your lordship.
Here, the governor's power also derived.
Indeed, your lordship. So because it was in violation of the UGC regulations, which as you stated,
See, rest of the issues has not been canvassed in that matter. Only the governor can recommend only 1 person has been sent by the government for the post of Vice Chancellor. That is the issue there.
indeed, your lordships. The UGC regulation mandate to
Yes.
nominate 4 candidates, and that was why it was held.
Sometimes the Supreme Court said, It is only a monitoring body, funding agent, they cannot, their words should not be taken into cognizance and all. But in this case, the Supreme Court held to know only one person's name has been recommended, the governor has the power to return it. That is the substantive case, some of your argument.
Indeed, Your Lordship. Your Lordships, further the council submits that the governor, acting as a chancellor, operates as a constitutional buffer between the autonomous university and the political executive, and replacing such a post with the chief minister or the educational minister collapses this buffer, Your Lordships, and it results in the concentration of executive power, institutional capture and politicization of higher education. And it erodes the constitutional trust, as was cautioned by this honourable court in the case of Nabam Reddy versus the deputy speaker, Your Lordships. And thus, removing the governor as chancellor, it destroys the constitutional architecture.
What is the necessity for bringing this up?
Your Lordship,
What is the necessity for bringing this up?
the state summon.
The state replacing government by...
Indeed, Your Lordship.
What happened? Oh.
Your Lordship, the union government passed the UGC regulations, Your Lordship, and the
I'm
government.
asking, what is the necessity? Why the state government got this amendment?
Your Lordship, the council on behalf of the respondent contends that it's completely unnecessary. Such a state amendment was unnecessary.
Why? Because the governor is not acting as per the advice of the council of ministers. That is why we are asking for.
Indeed, Your Lordship.
Please understand what my learned friend has said.
See.
When the chief minister has been selected and elected by the public,
And the head of the state is a concerned
being confined as a governor.
being
Independently reacts yes, against the interests of the state, whether he should be allowed to continue as a governor of the state or otherwise, a dummy man is allowed to be continued there without exercising their powers, being elected by the public, whether they can be appointed directly by the state government. That is the issue now. Before the Supreme Court also, is it not?
Indeed, Your Lordship.
Yes, not only the issue whether vice chancellor can, governor can act as a vice chancellor, that is not only a question now. Whether governor can be appointed by the state government itself, that is also a question. But you have given an excellent reply also to that. I think we appreciate it.
Indeed, Your Lordship, because the chancellor post as the petitioner counsel.
Now the governor is not acting as per the council of ministers. What is the remedy for state?
Your Lordships, if such a case arises, the remedies can be sought by the state government by approaching the judiciary as a part of.
We appointed the governor.
They approached, there is an order by the state government.
Indeed, Your
Now they gone to the Supreme Court, there is an order. Then another matter is gone to the full bench. It is a pending now.
Indeed, Your Lordship.
What will happen to the case?
Indeed, Your Lordships, but based on the articles of repugnancy 254, it is clearly stated in case of repugnancy, the central law will prevail. And UGC regulations.
There is no problem. What I am asking is that the governor is not acting as per the advice of the council of ministers. What is the remedy for the
Your Lordships, under Article 163 itself, it's clearly stated that
discretion?
a discretionary power, and also as a chancellor is a statutory position, he need not abide by the aid and advice of the council of ministers, Your Lordship,
Yes, you can put it.
as a constitutional position. Much obliged, Your Lordships. Your Lordships, in the case of Kannur University case 2023, which the council humbly submits, the Supreme Court unequivocally held that the chancellor must act independently and he is not bound by the aid and advice of the council of ministers. And it also declared that guided by the dictates of his own judgment and not at the behest of anybody else, Your Lordship. And thus, these rulings make it clear that the chancellor is not bound by the aid and advice of the council
That
of
does not mean
ministers.
that you can act independently. That's what the lady earlier occasion, your friend has pointed out that he is a friend. He must act according to his conscience.
Indeed, Your Lordship.
Yes, that judgment has been referred to Bhatiwala and Mahadevan recently now. That said, what is the power of the governor also by different way. You need not go to that, it is an overruled judgment. Not only overruled, that is slightly bypassed.
The powers are laid down, actually. They're laid down, well established, so you don't have to go into that now.
Discretionary powers.
Yes, it's laid down.
Much obliged, Your Lordships. Your Lordships, and the council further submits that the Constitution of India vests the power of assent exclusively to under Articles 200 and 201 to the governor and the president, Your Lordships. In the Constitution, there is no concept of deemed assent, Your Lordships. And according to the settled maxim, quando adequate prohibitor, ex derecho, prohibitor et per oblique, cautions against achieving indirectly what the Constitution directly prohibits, Your Lordships.
Your Lordships, though the advisory opinion is not binding on the court.
I asked Mr. Kusi.
Indeed.
Being lesson by
Your Lordship, deemed present was given by the Honorable
Court by exercising its powers under Article 142 in the case of State of Tamil Nadu versus the Governor of Tamil Nadu.
why you are saying being lesson, there's no provision at all.
Your Lordship, it is because
The judiciary possesses immense power with regard to regulating and facilitating timely constitutional functioning. But substituting as an itself should lack the distinction
What was
between
the distinction being the president?
presidential reference. I would like to submit the presidential reference. Anyway, Your Lordships, it was Indeed, Your Lordships, in the presidential reference, it was clarified that Article 142 may supplement but cannot supplant express constitutional provisions.
What I am asking is, I was asked the question, whether this presidential reference judgment is binding on the Supreme Court on this statement.
generally, Your Lordships, the advisory opinion is not binding.
Not binding.
Advisory opinion is not binding and I merely present this for the consideration of the Honorable Board.
That you are aware of it.
Yes, Your
Why
Lordship.
you put this?
For the consideration purposes only, Your Lordships.
See, 223 judgment, that is Padiwala judgment they have produced, a Kannur judgment.
Indeed, Your Lordship.
Slightly differentiate this judgment, and subsequently the Mahadeva with Padiwala, another judgment where the state of Tamil Nadu has been passed. And subsequently they have come to the full bench also.
Indeed,
Now
Your
in this case, the Justice Padiwala pleased to held that the governor is about an independent body and he has got his own enactment and he has got his own office and he has got his own secretariat. He does not
Indeed, Your
give
Lordship.
importance to the voice of the Council of Ministers. That is, the Act says that was incorporated by Justice Padiwala again. Subsequently, slightly it is modified, like his Lordship was sitting with Justice Mahadevan, and there has been gone to the full bench also now. No, you cannot report this judgment at present. It is a good judgment.
Indeed,
It
Your
has not been overruled, that has not been diluted,
Indeed,
but
Your
it is still in force. But that does not mean this is only the good law now. It is
Indeed, Your Lordship.
in the Act.
Indeed, Your Lordship, and also the same thing was quoted in an earlier judgment, the Burinath versus State of Jammu and Kashmir, Your Lordship. I would like to quote that also. And also in the case of Hadwarilal versus GD Kapazis, AIR 1982, PNH 439, the Governor's powers as Chancellor are strictly the creation of the statute. It has been mentioned, Your Lordship. The Council will take further notes on the judgment. Your Lordship, the Council seeks permission to move on the third issue. Much obliged, Your Lordships. Your Lordship, the third issue is whether the 109th Amendment altering Article 200 is valid. Your Lordship, certainly the Article 200 which has been amended under 109th Amendment, such an amendment is valid, Your Lordships, because the Parliament enjoys plenary constitutional power to amend the Constitution under Article 368, Your Lordships, and Article 200 is not entrenched or an excluded provision and therefore lies squarely within the amendatory competence of the Parliament, Your Lordships.
And Your Lordships,
The amendment does not violate but rather fortifies the basic structure, Your Lordships. Because in a democracy, ultimately vesting the power with the nominated governor, Your Lordship, the amendment states that
can I seek the MOOT proposition?
Your Lordships, in the amendment, in Article
Indeed, Your Lordship.
If not, he decided he will
Automatically transfer.
What happens if the president goes? Is the time limit?
Indeed, no, Your Lordship. The time limit is not fixed.
fixed for the President. But in the provisions which relate to the assent of bills, in President 111, it is quoted that as soon as possible.
That is the word same quoted in the
Governor's position. Indeed, Your Lordship. But the President being the head of the Union's constitutional head.
Same word is quoted in the president assent also and the governor's assent also.
Indeed, Your
As soon
Lordship.
as possible. Why is the necessity for being so?
Your Lordship.
Why you cannot frame any timeline for president?
Your Lordships,
Your Lordship,
Describe a timeline for the governor.
Indeed, Your Lordship.
Because it should not be kept as a pocket.
Indeed, Your Lordship, indeed.
But why you cannot prescribe time for president?
Your Lordships,
This amendment was passed because many bills were pending before the governor, and the governor was acting unconstitutionally because under the limits of powers granted to the council under the governor under Article 200, he cannot withhold the bill for prolonged inaction. Only to prevent this legislative deadlock and avoid any further deadlocks, this amendment was introduced, Your
I
Lordship.
agree with you. Why not here? Why is the route for time fixed for president?
Your Lordships,
It is presumed that a reasonable time will be utilized by the president in deciding.
That is the question now. That is the last, that is the back of that. You are, see, you being counsel for the union,
indeed, Your Lordship.
you are supporting this council. Because for unlimited time of let president can take it for pocket. You are pronouncing the judgment, you are asking for the judgment to keep president as pocket.
Your friend, Jurisdictional Council also pleased to point out yesterday,
Indeed, Your Lordship.
this extraneous circumstances would have not been expected by the constitutional framers. Everything will be go on well, so that they said the time limit has been prescribed to 6 months. Or otherwise that would have been, or otherwise that have been mentioned in the constitution itself, automatically it will become void. That has not been accepted by the constitutional writers of Ambedkar, Allah Deringa, T.T. Krishnamacharya, Munshi Gopal Semengar, everybody else. But they thought everything will go on well. In extraneous circumstances, what is the yardstick should be followed and amended? That is the question now. That is pending before the Supreme Court. You are excellently placed and they are also excellently placed.
Indeed, Your
See,
Lordships.
whether the assent of the governor is a must or if it's not done so within 6 months, what is the remedy? Automatically will go to the president. That is the one aspect, that is the voice of the state government.
Indeed,
That has been raised before the Supreme Court also. Now the Supreme Court initially passed an order, that is another, some slight changes will be there. That is one aspect. Now you confine your argument, what is the power of the governor and whether there can be, the governor or the chancellor should be selected by the government itself or otherwise by the appointment of the president. That you must confine your argument, reply to a learned friend. Going on traveling other aspect is concerned, that producing judgment will not strengthen your case.
Indeed, Your Lordship. Your Lordship,
This amendment was introduced only as a curative action for the indefinite inaction, and prescription of that 6 months timeline is because of the harmonious construction principle. In 201 article, it is stated that 6 months.
We agree with all your things.
Indeed.
Why you cannot prescribe time for president?
Your Lordships,
Because he's bound to act within a reasonable time as soon as possible.
That is what I say. What
Same can be applied here.
but indeed, Your Lordships, under Article 200, same can be applied.
But here the governor has acted unconstitutionally because the many bills were pending before the state. Almost 10 to 12 bills were pending before the state and no action was
The
taken.
argument of the Solicitor General of the Supreme Court. The president is the monarch of the state. Central government is concerned, the governor is the monarch for the state government. So that that is what you have produced the Saharabanu's case, Article 14. That is the discussion of the Supreme Court in the Saharabanu's case.
Indeed, Your
When the
Lordship.
14 is concerned is applicable equally to the central government, that is equal to the state government also. That was the discussion by the judges in the Saharabanu's case. You
Indeed,
go
Your
through it
Lordship.
thoroughly. In Adiyaman's case also, that is been discussion.
Indeed, Your
So in
Lordship.
this case, the time limit is the question now.
Indeed.
Second question is concerned whether the chancellor of the governor may be a chancellor. The two issues there, how long he can keep the papers pending in his table one. Other one is concerned he can be act as a chancellor or otherwise he can independently act or according to his conscience he will act or he can respect the advice of the ministers. That is the question now.
Indeed.
So none of them are answer to that question now.
Your Lordships,
The governor, while acting as a chancellor, is not bound by the aid and advice, Your Lordships, and he, while exercising chancellor, is constitutionally bound by all the other regulations which are mandated by the central government.
Almost respect the constitution, binded by the constitution.
Indeed, Your Lordship.
Come on, you are doing well, come on.
Your Lordships, should I answer the question why?
Sure.
Your Lordships, because we have introduced the 6 months timeline, because the concept is not a new or novel to the constitution. It refines an existing constitutional process to ensure functional efficiency, Your Lordship. And this is not intended by the union to usurp the powers of the state government. It is only intended to facilitate a better legislative process and procedure for the state government. There is no reason why the state government should reject such an amendment, Your Lordship.
Correct.
Indeed, Your Lordship.
In continuation of whatever my learned friend asked, with respect to what happens when the president sits over the bill. You have used these judgments, State of Punjab versus Principal Secretary to the Governor of Punjab in your memorials,
Indeed, Your Lordship.
to show that the governor cannot have the power of pocket veto.
Indeed, Your Lordship.
The president does the same thing now. You cannot use his judgment because now there is a vacuum with respect to what happens when the bill goes to the president. He can pocket veto. If you say that you fix the time limit for the governor, since you do not want governor to exercise pocket veto, the same thing happens now with respect to the president also. Justify that. You have not answered the question, my learned friend, on that aspect.
Your Lordships,
You have an answer, you can proceed.
Your Lordships, I contend that only it was a remedial measure.
Yes.
Indeed, Your Lordships. And as was stated earlier, Your Lordships, the President as the constitutional head is not as constitutionally bound. He is bound to act on the bill as soon as possible for facilitating the legislative measure for the whole country, Your Lordships. And such a position is presumed that it will not be misused. The backup is presumed that it will not be misused by the President, who is the constitutional head as well as the elected head by the electoral college, Your Lordship. It's presumed he will not misuse such a power.
We also have to finish it as soon as possible now, so let's finish.
Indeed, Your Lordship. Indeed, Your Lordship.
Repugnancy should be given by the other citizens.
Indeed, Your Lordship. The council seeks permission to proceed with the prayer. Your Lordship. Your Lordships,
And the council appearing on behalf of the respondents humbly prays that, wherefore, in the light of the written pleadings, the case is cited, the respondents most humbly pray that this Honorable Supreme Court of India
may be pleased to dismiss the petition filed by the petitioners as being
devoid of merit and misconceived in law, Your Lordships. It was an honor to argue before your
Written arguments we don't have anything. We are not supported any written argument.
pleadings, only pleadings. Your
Only
Lordship.
pleadings.
Pleadings.
You said that your written argument will be taken into cognizance. We don't have any written arguments produced by you.
Indeed, Your Lordship.
So you may give or may not.
Indeed, Your Lordship.
Sure, thank you.
The council seeks permission to retrieve from the dais, Your Lordship. Much obliged, Your Lordship.
Lordship permit, we shall proceed with the rebuttals.
What do you want to say? You have anything for rebuttal or not? Yes, come to the podium. Yes, your 30 minutes.
30 minutes, principal is very much waiting here.
We are running out of time.
Not to listen, no. To close us, she is watching here. We want to surprise you. That's why you are.
Counsel, whatever you have prepared, you can come.
You can argue now.
Who is going to argue now? Researcher.
You should not allow the court to wait for your honorable arrival.
No new points, no new points. Only rebuttals to whatever they said.
Much obliged, Your Lordship. The researcher seeks permission to proceed with the rebuttals. Much obliged, Your Lordship. First of all, much obliged, Your Lordship. First of all, I'd like to state that the opponent counsel has stated that the governor will become a puppet of the state government. I'd like to state that the president nominates 4 candidates. So the union also has a say in this. The state legislature only chooses one of the 4 candidates appointed by the president. So there is no way that the governor can become a puppet of the state. Much obliged, Your Lordship. Also, I'd like to state that the 108th amendment does not, 108th amendment restricts the evolution of the constitution. The 107th amendment passed in the year 2020 is seen as a constitutional evolution. In order to provide a little state autonomy, the 107th amendment was passed stating that much obliged, Your Lordship, stating that the state legislature has can choose one of the candidates appointed by 4 candidates nominated by the president. So it is a constitutional evolution, and the 108th amendment, which nullified it, has diminished this constitutional evolution. Also, I'd like to state that the opponent counsel pointed out the 108th amendment was passed with 350 seats majority. Similarly, the 107th amendment was also passed with 3/4 majority, Your Lordship.
See, the amendment has been brought in, okay, 3/4 majority, no, 2/3 majority, not 3/4. 2/3 majority.
2/3 majority, much obliged, Your Lordship.
2/3 majority. What I am asking is whether if the bill is passed with the 2/3 majority, whether it can be tested in the court of law.
Much obliged, Your Lordship. It can be tested before the court of law.
So you are here.
Much obliged, Your Lordship.
Of course, we permit you to say what is 107 states.
The amendment 107, Your Lordship. 107th amendment was made to 3 articles, 155, 156 and Article 158. Clause 1A was inserted, Your Lordship. Before the amendments, Article 155 read that the president shall appoint the governor. But after the amendment, it states that president shall provide 4 nominees, out of which the state legislature will select one through secret ballot. Article 156 states that president shall remove the governor will be removed at the pleasure of the president. But Article 156, the amended version, states that the state legislature can pass a motion, and through again elections they can by voting they can remove the governor. Article 158 1A, which was newly inserted, states that the governor shall be a politically neutral person.
The one question is raised to the Supreme Court. When the governor was removed by the president, an ordinance, it was stated before the Supreme Court is the pleasure of the president. But the pleasure of the president has been defined only when he was removed from it. The Supreme Court said when the appointment also comes under the purview of the pleasure.
Pleasure of the president.
Pleasure is concerned for appointment
as well as
also. You did well.
Much obliged, Your Lordship.
Thank you very much.
No, already we are exceeded.
Anything you like to say? Yes.
So if you have any server rebuttal, you can come. Otherwise, you can.
There is a separate marks for it.
You can choose anyone as your 3.
You can add up.
The opportunity has been given to them, you can avail the opportunity.
Your Lordship, petitioner submitted many recommendations.
Only with respect to whatever rebuttals were made. Answer only to rebuttals made.
Petitioners submit many recommendations, but they don't have a binding nature.
Counsel, you can freely argue. It's an opportunity. You can freely argue.
Make your submission. Freely, don't worry. We'll give much time to you. Respondent பயப்படுறீங்களா? How are you? Yes, you can. We will not permit any proxy at all.
Your Lordship.
We will not permit any proxy to argue, but for you, we are arguing. We are allowing you to argue. Come on.
Indeed, Your Lordships.
Only 1 minute.
Indeed, Your Lordships. Your Lordships,
They contended that we have mentioned that the governor will be a puppet of the state legislature, Your Lordship, but under the 107th amendment, it destroys the neutrality of the post of the governor, Your Lordships. Only for that purpose we made the contention, Your Lordships. And also the learned counsel contended that the governor is not responsible to the people in their arguments, Your Lordships. Do they need to question the basic features of democracy of this Indian constitution, Your Lordships? And Your Lordships, they also contradicted their own statements, where they mentioned that the 108th amendment, which restores the original constitution, is violative of the basic structure. The constitution is a document which the whole of the country is bound by, and how can they contradict that it is violative of the basic structure, Your Lordships?
You have excellently replied to the question. They should not use the word puppet at all. The same word has been used before the Supreme Court. The Supreme Court don't use that word. Say it's a glorified post.
Indeed, Your Lordships.
Yeah, the powerless glorified post. Don't use the word puppet. Then you are rightly replied to them. Yes, correctly.
Your Lordships. Further, they also submitted many recommendations, Your Lordships, but like the advisory opinions sought by the court, the recommendations were also not binding on the Supreme Court or the central government, Your
The
Lordships.
same thing the Supreme Court also said, he does not have any power directly, and he has got indirect power vast
Indeed, Your Lordships.
for the assembly. Everything has got intact. That's what Supreme Court said. The government does not have any direct rule, but he has got the vast power intact. Indirect rule, the indirect power he has got.
Indeed, Your Lordships.
Yes, that does not be specified in the constitution, but he has got a much power.
Indeed, Your Lordships.
Even Chief Minister cannot use the numberless call, he may use. That is the provision of the constitution. So there is not a number. Tomorrow he may announce from the Secretary, tomorrow assembly will be.
Indeed, Your Lordships.
Chief Minister cannot do that. Government is not the Supreme Court, the indirect power.
Indeed, Your Lordships. Governor has many powers, even with respect to Congress. Much of that.
Yes.
Your Lordships,
You have faced all the questions on that. Good.
Indeed.
You did well.
much obliged, Your Lordships.
The council seeks permission.
We have to wind up.
Rise up.
Kind attention to all the audience, please listen. We request all the participating motors to assemble in the academic block lawn area for a group photograph immediately now. The chief guest has arrived, so we will have a group photograph and then we will assemble back in the auditorium after the group photograph. Faculty members kindly facilitate the same. Make sure all the other college participants are assembled in the academic block right now for a group photograph. Following that, the volunteers and the faculty members will also have a group photograph, but first make sure the other college students are assembled there immediately. Please proceed to the academic block right away. We request all the 30 teams to assemble in the academic block right now.